Welcome, everyone, to the Judicial Proceedings Committee. Today is Wednesday, March 30th, and we are hearing House bills here today. We have the order of bills, but we may need to be flexible as delegates come and go. The official order is HB 206, HB 29, HB 230, HB 813, HB 1076, HB 1143, HB 1262, HB 1021, HB 1314, HB 868, and a Senate bill, HB 977, at the end. I don't see Delegate Moon in attendance, so we'll go to my teammate, Delegate Carr, for HB 29. I am the cross-file, so this is a wonderful bill, but I'll let Delegate Carr tell you why.
Thank you, Mr. Chairman. Good afternoon, distinguished members of the Judicial Proceedings Committee. For the record, I'm Delegate Al Carr, and I'm pleased to present House Bill 29. This bill would repeal the Maryland Transportation Authority to suspend vehicle registrations for toll debt. And so that part of the bill passed the House in 2020 and 2021. What is different about the bill before you is that it is an emergency measure, and it also adds language requiring a performance audit similar to the approach that the General Assembly took in 2019 for the University of Maryland medical system. Maryland is an outlier in allowing the suspension of vehicle tags for video toll debt with a $25 late fee on tolls as low as $1.40. This practice contributes to the criminalization of poverty. A better practice that many states use is to simply flag the registration for non-renewal. In 2020, MDTA created their own perfect storm by deciding to permanently implement statewide cashless tolling while the dust was still settling on their once-in-a-generation vendor transition, and also after they had paused the mailing of video tolls and ICC Easy Pass transactions. The resulting dramatic increase in backlogged transactions that had been hitting drivers in 2021 and still today underscores the importance of fixing the policy. MDTA argues that this bill would result in the greater accumulation of toll debt, but keep in mind toll debt is mostly comprised of the late fees rather than the actual underlying tolls, and MDTA does have the ability to reduce that late fee amount. So I respectfully ask for your favorable report.
Questions for the sponsor? Let me just say on camera what I told the sponsor privately. We had this bill in this committee. It was clear that Budget and Tax also was dealing with this issue. I didn't want to do anything that would accidentally counter what Budget and Tax was doing. In speaking with the sponsor of this bill, it's clear that this bill is complementary with Budget and Tax and that both ideas can move in concert and don't accidentally conflict with each other. But that's why the Senate bill hasn't moved, even though I believe we have the votes to do so. So thank you, Delegate Carr. Let's move on to your next bill, House Bill 230.
Thank you, Mr. Chairman. Good afternoon, JPR colleagues. For the record, Delegate Al Carr here to present House Bill 230. Unsafe driving behavior has been a concern for many years. It's only increased during the pandemic. House Bill 230 will help make our streets safer. Under current law, a person who endangers you or your family by driving at an unsafe speed or blowing through a red light can do so with impunity if they happen to be driving a rental car. That's because vehicles owned by a rental car company are exempt from receiving speed and red light camera citations. House Bill 230 would end the exemption. Maryland is an outlier of all of the states that allow automated camera enforcement. Only Maryland and Georgia exempt rental cars. How often does it happen that a vehicle owned by a rental car company is detected racing by a camera? It's not a small number. In Montgomery County alone, it happens about 40,000 times a year. This represents about 9% of the potential citations that are simply discarded. On state highway work zones, it happens about 24,000 times each year. In Baltimore City, where the speed cameras are in school zones, about 30,000 drivers a year speed past our kids. House Bill 230 follows the model successfully used in Washington State under the bill. If a vehicle is a rental, a notice is sent to the rental car company. The company then has a certain number of days to respond back with the name and the mailing address of the renter so that the citation can be sent directly to the renter. This approach works successfully. The rental car companies there are able to respond back with the driver information. The bill includes language that was suggested by Maryland-based Nextcar, and it helps rental car companies and local agencies by automating the process. There's no need to mail all these citations when they could be transmitted electronically to the rental car companies. That's the way it's done with tolls in Maryland, and so that would make things easier. So with that language, Enterprise, which opposed the bill in the House, they dropped their opposition. And in the interest of safety, I respectfully ask for your favorable report.
Thank you, Delegate. Senator Heddleman.
Thank you, Mr. Chairman. Thank you for this bill. I actually had no idea. And I think it's an important bill. I'm just curious whether, you said that Enterprise dropped their opposition, and I saw the mayor's office opposed it. I wonder if you could address that.
Yes. So as introduced, there was a letter of opposition from Baltimore City. However, there was a misunderstanding. They were under the impression that rental cars were not exempt and that this was imposing a new requirement to send these notices. And when they learned that rental cars are exempt and that we're simply repealing that exemption and providing a mechanism, they submitted supplementary testimony in support of the bill, which they've done also for this committee.
Okay, thank you so much.
Thank you for that clarification. Senator Sidnor.
Thank you very much. And just to follow up, so the supplementary letter that we said was support with amendments, or the amendments or whatever that they were looking for, is that incorporated in this version of the bill?
Thank you, Senator. The answer is yes. Those amendments are incorporated into the bill. The amendments are basically to allow the, notices and citations to be transmitted electronically as opposed to in the mail.
Thank you.
Other questions for the sponsor? All right. Thank you, Delegate Carr.
Thank you very much.
Appreciate your being here. Delegate Carr emerges unscathed from JPR. Delegate Weibel, you're next for House. Yes, that's right. House Bill 1076.
Thank you, Mr. Chairman. It's good to be with you and honorable members of Judicial Proceedings. I am Delegate Weibel, pleased to present House Bill 1076. It authorizes the MVA to issue an electronic or digital 24-hour vehicle registration. What the passage of this bill would allow a purchaser of a vehicle to legally transport it on the roads of the state of Maryland for a very short period of time, 24 hours or less. And I say legally because I think currently many of these vehicles are possibly being transported either without registration, by switching tags from another vehicle, or possibly just running them without tags, or it also would prevent them from having to be towed from the site. This bill was brought to me by a constituent who operates an auction house, and there are many circumstances where vehicles are not purchased through an authorized dealer, and they do include auction houses, purchases through private means, or purchases through estate sales. The bill in its form is currently patterned after the state of Virginia, which does offer a 24-hour vehicle registration. It's a very simple bill. I ask for a favorable report. Thank you.
Great. Questions for the sponsor? Thank you so much, Delegate.
Thank you.
Appreciate it. Delegate Moon, Mr. Vice Chair, you are next, but take a moment if you need to get settled or get prepared in any fashion. You have two bills today, a delegation bill and your House Bill 206, so whichever you would like to take first.
Sure, thank you, Mr. Chair. House Bill 206, it's a cross-file of a bill you've already heard in past. It relates to repealing a sweep-all driver's license offense prohibition that's likely unenforceable. The only thing I would note for you is that E&T put an amendment on the bill that would, it kept the repeal of the sweeper provision, but they added in keeping an offense for cheating on a driver's license exam as a new offense, because I believe the administration flagged this as one possible use of the sweeper provision that may be missed by repealing it. I honestly don't have strong feelings on what you do with that, assuming the underlying repeal is maintained. And so I think that's all there is on House Bill 206.
Yep. We did. This is the cross-file.
This is the crossfire, but she didn't have that amendment that you talked about.
That's correct. So my understanding is we're hearing House bills that are in a different posture.
Gotcha.
And because of that amendment,
The
it's in a
amendment
different
changed this.
posture. Yeah,
Okay, you don't care about the amendment. Okay, thanks.
great. Any other questions for this sponsor about this bill? If not, that concludes the hearing on that bill, and we'll move on to House Bill 813, which is a Montgomery County delegation bill.
Thank you, Mr. Chair. House Bill 813 is a Montgomery County delegation bill passed unanimously. All the bill does at this point is it creates a reporting on some of the school bus cameras, which I don't know if your county has, but they're on every school bus in Montgomery County. And there was some concern about how these cameras are located, so we're going to get some reporting to ground future work on that. It also, in uncodified language, has a deal represented between Montgomery County and the Assembly to try and use non-fine-based means like moving school bus locations if it's warranted.
Great, and I apologize for not knowing the answer. Has the Senate delegation voted on this bill?
I believe that's right.
Okay. Senator Sidnor.
How you doing?
Hello.
Just a quick, what do you mean by how they're located? I'm curious.
So, under state law, you get a ticket for a school bus camera if you're behind the bus and you don't stop. But if you're in the opposite lane, you get a ticket if there's no median in the road and you don't stop. But if there is a median, you don't get a ticket. And so it's been confusing to some drivers, because in Montgomery County, some of these state highways are 8 lanes. And so the expectation is the driver opposite side of the road in lane 8 needs to stop, or they're getting a $250 ticket.
Oh, they
And
need
so-
to stop.
Oh, yeah. This is state law. So I would caution those who have these programs to take a look at this aspect. And so we have some bus stop locations in downtown Silver Spring that are netting $1 million a year in fine revenue. And the reason for it is because it's an 8-lane state highway with school bus stops along it. So this is a true policy problem that we're trying to address.
Thank you.
Senator West.
Thank you, Mr. Chair. It sounds bizarre. The whole purpose for requiring cars to stop is so children who get off the school bus can go across the road. But do children really go across an 8-lane highway?
Well, this is the question we're trying to ask. And so we've been slightly skeptical about the location of these school bus stops. And the data has been showing year over year that the fines are not reducing the behavior. In fact, in these downtown school bus stops, you're seeing escalating numbers by the thousands of infractions per year. And so to leave the stops there and know the fines aren't reducing the offenses, and yet we're calling this a dangerous bus stop, it just seems like something's not working. So we tried to get at it immediately and say, why aren't you building medians on these roads or looking at other engineering treatments? But of course, people complained that that was a costly way of handling this.
Or why not require the school bus to turn into a neighborhood street and have the stop on the neighborhood street?
That's one of the possibilities. I would just caution you that there is parent resistance at some of the, it might be that there's an apartment tower located on a main road. And so if you move the bus stop to down the street, it's many families who live in that apartment will then be traversing away from where they live. So again, I concede the point, and I guess what we're trying to do is force all of the parties, the law enforcement, the school bus route creators, and the Department of Transportation to sit down together and come up with an overall plan for where to locate the stops, whether there's proper signage and markings warning people about this. And frankly, the citations weren't in 2 languages, et cetera, things like this in places where many of the drivers were going to be, in fact, non-native English speaking.
Well, the bill makes every bit of sense.
Thank you.
Other questions for this sponsor? Thank you, Mr. Vice Chair. I believe we'll be beginning to vote House bills very shortly. I'm working under the assumption that the House will be beginning to vote Senate bills very shortly.
We
as
will
well.
try to do the same. Thank you very much.
Thank you, Mr. Vice Chair. Just going in the original order here, Delegate Buckle, I believe you're next for House Bill 1143.
Thank you, Mr. Vice Chair. Members, you know well enough, don't necessarily believe Delegate Moon when he tells you that. I can tell you all know him well enough. House Bill 1143 is really a very minor bill. It's the Allegheny County and Garrett County Delegation bill. The cross file here in the Senate, I believe, was late filed, and we just elected to move through this vehicle. It passed unanimously in the House. What it does is it simply expands the definition of all-terrain vehicle for a certain limitation or regulation that exists only in Allegheny and Garrett counties about your ability to use such an all-terrain vehicle to cross public roads, and it expands then that distance requirement from 2 miles to 5 miles, and also includes snowmobiles. The reason why this exists in a nutshell, Allegheny and Garrett counties are trying very hard to expand their tourism economy through the use of things like there's some parks that have been developed, Wolf Lodge, Wolf Trail, that's in Garrett County, not in my district, but there are some other places that are coming in, St. John's Rock, that are beginning to attract groups and individuals who want to use these interconnecting trail systems to try to do outdoor recreational activities, which is a big focus, obviously, of the legislature this year. And because of our unique terrain, topography, and our interconnecting road systems, sometimes you can't get from one trail area of the park to another area without the ability to cross a public road. And so we certainly don't want people riding improper vehicles on those roads, but these have been vetted by the experts to expand that definition of all-terrain vehicles to vehicles that would be road appropriate, or sometimes when you have snowmobiles, you have heavy snows in western Allegheny County, farther west than me, and Garrett, and they can use the snowmobiles to traverse a county road that has been snowed over to get from one area of a farm to another. And so none of those folks want to get in trouble with the long arm of the law, and the law enforcement folks don't want to be out chasing these people down and looking for very technical definitions. And so it was requested that we pass this bill to alleviate any concerns under the existing law.
Thank you, Mr. Chair. So how did you like testifying in person?
It's the first time I've done it in about 2 years, but, we do so many amendments on the House floor that after a while, it just seems very natural. So, yeah, it is first time in 2 years. It's nice to see everyone's faces except for Senator Huff. No, I'm just kidding. Just kidding. Just kidding.
Well, you don't have long, he's leaving us,
Yeah.
All right. Further questions from the committee? All right, thank you very much.
Thank you very
Great
much
to
for
see
your
you.
consideration. I appreciate it.
Excellent. And with that, that'll end the hearing for House Bill 1143. We'll now move on to Delegate Moutz with House Bill 1262.
Good afternoon, senators, colleagues. It's great to be back. And Delegate Buckle was kind of played it off, but I can tell you I am tickled to be able to testify in person. It's great to see everyone. HB 1262 is a bill that's been introduced in the past on at least one occasion. It got caught up with COVID. Prior to COVID, we had a horrific accident in the town of Oxford, just as you enter Oxford. Oxford's a one-lane town. You drive into Oxford. We've had repeated problems with speed controlling, and we've implemented a number of measures. State Highway has helped us with some road markings, we moved the speed limit out further. We've done all sorts of things. But on one particular day, there was this incident that just struck the nerve of everyone, and the town has asked us to get authority to put a speed monitoring camera at the entrance of town. It's a logical place. It's fixed. It's right across the street from the local fire company. In the past, this has been a cross-file bill. This should have been a cross-file bill this year. There was some confusion. So as a result, this is the only version of the bill that's still alive. So anything you can do to help us move this forward, we'd be greatly appreciative. And it is a delegation bill.
Thank you, Mr. Chair. So we've been dealing with these speed monitoring bills all session, and they're really bedeviling. So why can't the town of Oxford just have a screen there that says how fast you're going, that flashes off and on, and deter speeders in that way, or have the town police occasionally sit there and catch people on their speed guns and give them tickets?
They have both of those already.
It's just not enough.
It has not been enough.
Okay.
Yeah. On this particular incident, the president of our Women's Auxiliary for the Oxford Fire Company lives across the street from the fire company. Her family, grandchildren were at the house visiting. She had a meeting at the fire company. The fire company across the street was full of firefighters. The ladies' auxiliary was also there. And she was leaving her family from her house to walk across the street. It's a one-lane street. This room is wider than the street. And as she walked across the street, a motorist from out of town ran her over and took her life in front of her family and all the members of the fire company. So, and I'm not a big fan of speed cameras, and they're not a big fan of me either. But this has gotten the support of the town and the county, and so I'm here to present it today and urge your vote for it.
Further questions from the committee? All right, seeing none. Thank you very much, Delegate. Good to see you.
Thank you, Mr. Chairman. Good to see you also.
Likewise. I got to come down there and see you in Oxford. Or St. Michael's again. That was fun.
That's right.
All right, so with that, that'll conclude the hearing for House Bill 1314. We'll now move on to the Howard County delegation. Is that Senator Hester? Are you presenting for that? House Bill 868 or?
I think he still has.
Oh, sorry. Delegate Mouts, sorry. You have House Bill 1314.
Yeah.
Please proceed. Yep, there you go.
Sorry, Chairman.
Yeah.
I thought I was going to get mixed up. So the next bill I'm presenting today is House Bill 1314. This is not a delegation bill. This bill would authorize the Motor Vehicle Administration to implement a pilot program for new types of license plates, specifically sticker license plates. Originally, the bill went in and it was designed after a California pilot project that exists that was focused on EVs, electrical vehicles. The bill's been amended slightly that would allow this pilot program to apply to all vehicles. So some fossil fuel, some gas engine vehicles, they're not designed to have plates on the front. This has been an ongoing saga, fighting over this front license plate. And this sticker license plate option seems to be something that might be able to work. And I believe MVA has said that they can execute a pilot program. And I'd urge your favorable report for the sticker license plate program.
Thank you. Good to see you, Delegate Motz. I was at a store the other day, and I saw an electric vehicle with this sticker that from a distance looked identical to a regular license plate. And I said, wow, how about that? You don't have to, mess your vehicle up, and this thing looks like a most perfect decal I've seen. Are they currently illegal in Maryland to do that?
Currently, that is not a Maryland authorized license plate that's on the front of that vehicle.
I mean, because it literally had the registration and everything. It was great.
Yeah.
And I thought it was a great thing to do. So I appreciate you bringing it forward. I thought it was already legal.
Yeah, in fact, it's not already legal, but it's very fortunate that you should have the opportunity to see one,
I did.
see one in practice. I did not arrange for that to happen.
I did.
That's a coincidence.
All right. That's right. That's right. Thank you very much.
Thank you.
Hello, Delegate. Any questions, further questions for this sponsor? Seeing no further questions, thank you so much.
Great to be
We
with
really
you. Have a-
appreciate you
have a
being
great
here.
day.
Good to
Thank you.
see you. We'll now go to Senator Hester for a Howard County delegation bill. Nice to see you, Senator. If you have witnesses for your bill, please go ahead and bring them up if they would like.
Thank you very much, Mr. Vice Chair, members of the committee. It's great to be back here again. Today I'm presenting HB 868, the Circuit Court for Howard County Judge. For the record, Senator Katie Fry Hester. Members of the committee, thank you for your consideration of House Bill 868. This is a local bill that would transfer the responsibilities of the Orphans Court to our Circuit Court, subject to the approval of Howard County voters in the next election. This bill was originally introduced to our Howard County delegation by then Vice Chair of the Judiciary, Delegate Atterbury. And she studied this for several years. This legislation stems from several years of internal debate within Howard County as to whether or not we should retain our Orphans Court. Currently, only 19 counties in the entire United States have an Orphans Court, and we're one of them. Transferring the responsibilities to the Circuit Court would first of all ensure that our legal matters are handled by experienced attorney judges who have been vetted and trained. Second, it would reduce the number of overturned rulings, of which we have had many. It is also worth noting that transferring these responsibilities would increase the Circuit Court's workload by less than 2%. Passing HB 868 will give Howard County voters the opportunity to reduce unnecessary judicial bureaucracy and improve the quality and efficiency of the estate process. I'd just like to point out that you do have a letter from our delegation, and the bill passed in the House Committee 17-3 and on the floor 120-10. And it passed our delegation and all these committees with bipartisan support. So I'd like to respectfully request your favorable report on HB 868 and turn it over to my lead witness. And just so that we know, how much time does our lead witness have?
I believe it is 2 minutes.
Thank you so much.
Sure, thank you.
Well, good afternoon, Mr. Vice Chair, members of the committee. Thank you, Senator Hester. For the record, my name is Byron Mcfarland. I'm the Register of Wills for Howard County. I've spent many years in government, including, it's great to be back in Annapolis. I used to work for Senator Casemeyer and over in the House of Delegates as well. It's good to be back. As someone who spent a lot of time in public service, I believe in government. At its best, it can be a tremendous force for good in people's lives. It can only do that, though, when it's responsive to the needs of the public and when it's capable of reform and change. As a register, it's pained me to watch a system that is very much in need of such reform to meet the needs and expectations of our residents and to provide a more efficient, more effective, and more equitable process for our families. This institution currently is part-time, which leads to inevitable delays. Being comprised of 3 judges instead of 1 leads to inevitable disagreements. And with no required legal education or substantive judicial training, it leads to chronic misinterpretations of law, a lack of respect for judicial economy, and ultimately a longer, more expensive, and less just process for people who are going through the hardest time of their lives. To be clear, this system seems to work just fine in many parts of our state. In Howard County, it does not. Our delegation has labored over this issue for years, ultimately deciding that this legislation was needed to provide the kind of confidence the public needs in its probate court. While estates and trust attorneys in Howard County and across Maryland who practice in our county have felt that they could not be here personally to testify on this bill, I can tell you without question that they overwhelmingly support this measure. What we ask for today is the same deference that 5 other jurisdictions in our state have had in the past: Baltimore City, Baltimore County, Prince George's County, Harford County, and Montgomery County, that have implemented fundamental reforms to their courts in the past. This bill, as Senator Hester mentioned, passed overwhelmingly in the House of Delegates, and I respectfully ask for a favorable report. Thank you.
Just really, first, Mr. Farley, it's nice if I get to see your face. I put your name on a lot of envelopes going back and forth with your court.
And I think I've seen you via Zoom as well.
Yes, so anyway, yeah, good bill. It works well in Harford and in Baltimore County and the like, and I think you'll like it this way. So thank you very much.
Thank you, Senator.
I have a testimony here from at least two of the three judges on the Orphans Court opposing this bill. What about the third judge on the Orphans Court? Does the third judge also oppose the bill?
She has taken no public position on it.
Okay, so two Orphans Court judges oppose the bill. What about the judges on the Circuit Court in Howard County who will have to sit as Orphans Court judges if the bill passes?
The
What
Circuit
position
Court-
have they taken?
The Circuit Court has also taken no position.
No position. Because I will tell you, if I were a judge on the Circuit Court, the last thing I would want to do is to have to go sit as an Orphan Court judge, which does an awful lot of ministerial kinds of things rather than judgy kinds of things. Do you know whether, I think there are only two counties in the state where currently the Circuit Court judges serve as Orphans Court judges, in Montgomery County and Harford County. Has there been any kind of a survey taken of those Circuit Court judges to find out whether they appreciate the requirement of sitting as Orphans Court judge?
Yes, actually. Senator, you sat on the task force on
I
the
did,
Orphans Court this
yeah,
past year.
But there was no survey that had been taken.
Yeah, the chairman of that task force decided not to survey them.
Right.
There was a suggestion during that task force that those jurisdictions revert back to an elected Orphans Court, which I'd never heard of before. That did prompt a response from the administrative judge of the Circuit Court in Harford County, in which that judge stated, and this is part of the record for the task force, that they are pleased to have that workload and to continue to take it on.
Okay. All right. I also, are you aware that the Orphans Court judges in Baltimore County, I think all three of them, sent us some testimony opposing this bill?
Yeah, I think it's unfortunate that this is a local issue that, for whatever reason, has become more than a local issue. This affects Howard County and Howard County alone. You know, in 2010 and 2012, three jurisdictions, Baltimore City and Baltimore County, came to the legislature. Their delegation said, we would like to reform our court. And in those jurisdictions, they asked to require their judges continue to be elected, but that they be attorneys. The changes in Montgomery County and Harford County were made, frankly, before I was born. They were made back in the 1960s and 70s.
Right.
Those systems have existed for a very long time. And so there's a long history here of local deference when our delegation says, after consulting, after having public hearings, after looking at this for a number of years, they've decided that this is what's best for us. This has no impact on Baltimore County. This has no impact on Wicomico County or any of the other courts that have written into this committee or over in the House. So why they have taken such an interest in it, I'm not sure. And frankly, I mean, I know many of these judges around the state. You know, the Baltimore County Orphans Court has a great reputation. I don't hear any complaints from the bar about that court or in Baltimore City or most of the state. That's a very different story than what we have in Howard County.
Well, why is there this dysfunction in Howard County? You're an elected official, as are the three Orphans Court judges. So you want to change the Orphans Court system, and the Orphans Court judges want to keep it the way it is. So why is there so much dysfunction?
Well, we start with the fact that it's an elected court, that they're not required to be lawyers, that they're part-time. This is all part of the problem. Let me give you a couple of examples of why this isn't, you know, from my perspective, and I think that if you talk to attorneys in Howard County, you would hear the same thing. This is not really sort of an option. This is really more something that we really need to get done. Just recently, actually this session, Senator West, you sponsored a bill that was requested by the Bar Association having to do with courts denying fees and commissions. When they're at the statutory max, there are consents from all the interested persons, and courts are denying them.
Yes.
Fortunately, I thank you for sponsoring that bill.
And we passed that bill.
And we passed that bill, yes. It's been heard over in the House. Senator Sidnor, you asked during that committee hearing, members of the bar who were here, you asked, was there any particular court that this is a problem, any particular judges? They didn't want to answer that question. I'll answer it. It is Howard County. And we had two back-to-back rulings by our court that I think ignored the plain language of the law, and this is the problem with not having vetted, fully trained. You know, our circuit court judges go through a thorough vetting process. They have to have been a practicing attorney for decades. They have to know about courtroom decorum, and those orders were issued last year. One was reversed on appeal 2 weeks ago by our circuit court, and it wasn't just a reversal, The court found that the court misinterpreted the statute, exceeded the scope of its statutory authority, and had invented local rules that are impermissible under the code. And I want to make sure that we think about this not in the abstract, but in terms of the real impact this has on people's lives. These are two families. One was 6 cousins and a friend. The other was 3 siblings. Their estates were delayed by 14 months because the court got this wrong. And I think that, and then we had a circuit court judge take one look at it and get it right the first time. And that's really, why we need to do this.
Okay, thank you.
Yes, thank you very much. As this committee may remember, I'm usually a data-driven person, and I asked a lot of the same questions that you asked, Senator West, during the local hearing, and I was convinced by the number of appeals for Howard County, which were exceptionally high. So our circuit courts are actually dealing with these cases, once they finally get there. And I'd just like to remind everybody that this is a local bill, and it's going to be on the referendum, so it's really local.
Thank you, Mr. Chair. Just a couple things, because, Senator West and I did serve on the Orphans Court Task Force in the interim. And, the goal was to come up with, best practices to propagate throughout the state related to Orphans Court. And I don't recall, Howard County having an issue. And while I do understand it is local by nature, there are some that believes, and I'm quoting here, the attempt to abolish a part of the judiciary has potential ramifications, creating a snowball effect across the entire state. And so 2 questions. What is your position again?
Register of Wills in Howard County.
Register of Wills. A letter that I received from other orphans court judges throughout the state, and I won't list the county that they come from, seem to suggest that this bill is mostly driven by personality conflicts between one serving as clerk to the court and the judges, and that the regular voting process and folks retiring would resolve this. Can you respond to that, please?
Like I said, I'd be happy to get you the actual appeals that we've had, the numbers of appeals.
So I understand that, Senator, and let me just hold you for a sec, because one of the things that we tried to do in terms of judging how good orphans courts were, I said, well, what if we look at appeals? The rate things are being overturned. And I was told, not being a judge or attorney, right? I was told that you couldn't use that as a measuring stick to determine the effectiveness of, the judiciary. You just could not do it. And so when we were trying to come up with metrics that we wanted to send around for questionnaires, that was one of the things we intentionally did not use. Care to comment?
Yeah, a couple of comments. On the personality issue, I'll be blunt. I know conspiracy theories are in vogue these days. As I mentioned, I work down here. The idea that I or our delegation would come to you with legislation because of some personal grudge is simply obscene. Working as a lawyer, as a politician, you have to interact with people who you may not like. That doesn't mean that you try to, abolish their job. So I don't find any merit in that contention at all. And frankly, I think it's libelous. And I've read all of these letters from these judges, and I think it's a significant problem when judges present public testimony to this body or any other public body without any firsthand knowledge of what they're talking about. On the appeal issue and on the task force, of course, the task force, with all due respect to the chair of that task force, was a lay judge. And my understanding from speaking to other judges in the state is that, this kind of deep dive was simply not going to happen. And as you know, that task force didn't start its work until late in the year. And I respect your service in that task force. I thought there were some interesting findings that happened, but appeals are an important measure. And let me break down, as I mentioned before, we basically have 3 different kinds of orphans courts in Maryland, 19 jurisdictions like Howard County, have an elected court where there are no requirements for holding office other than you're 18 years old. 3 jurisdictions, you're required to be a member of the bar in good standing. And in 2 jurisdictions, you have a circuit court sitting as the orphans court. Those courts are appealed least often and reversed least often. The 3 jurisdictions, Baltimore City, Baltimore County, and Prince George's, your jurisdiction, where the judges are lawyers, are appealed second most, and then it's the lay courts that are appealed the most. Those are the facts.
Could I just follow up? Thank you, Mr. Chair. So I also want to thank you, Senator Watson and Senator West, for serving on this committee. I asked Delegate Atterbury for a copy of the report when this was going through, and then I wrote back, I'm like, it doesn't look like this report actually addressed the issue at hand. And so I don't know, it seems like if it's such a big issue, the task force should have addressed it, but then I looked and it was an orphans court judge who chaired the task force. I don't know. I just want to go back to the facts. First of all, this is a local bill. Hartford and Montgomery County are 2 counties in Maryland that have recently done this, and it's working well. Second, 36 states have their orphan courts duties overseen by trial courts, and 15 states have specialized probate courts. In PG County, Baltimore County, and Baltimore City, they all require their orphans court judges to be barred attorneys. Meanwhile, Howard County has a 3-judge panel who do not have to be attorneys, and we have a very high rate of appeals. This is a local bill, and I would respect your favorable report.
Thank you, Mr. Chair. How you doing, sir? Just a couple questions, because I was surprised at the number of letters and things that we got outside of Howard County as well. I know at least one of your orphans court judges is an attorney, and she is in opposition to this. Are the other 2, are they not attorneys?
One's an attorney and one is not.
Oh, so it's 2 attorneys and, okay.
Right. But there's no, if I can just say that, there's no guarantee in any given election that we will elect. It's actually a recent trend it's only in the last 20 years that we've elected attorneys to our court. So there's no guarantee that in any given year we couldn't elect 3 lay people.
And which is going to lead to my next question. Rather than going to the immediate route of just blowing up the court, had you all considered maybe putting in the requirement that there are attorneys that would sit on the court?
We considered that, and I think the issue with that is that it's a couple things. First, the court does not have the caseload. When we look at jurisdictions like Baltimore County, Baltimore City, Prince George's, those orphans courts have a large caseload, and it's enough for 3 lawyer judges. They sit one at a time. In Baltimore City, Baltimore County, you have an attorney judge sitting every day because of the caseload. In Howard County, if you had 3 judges taking care of the orphans court duties, they would sit 1 day a week every 3 weeks. So, I mean, we're talking about a pretty part-time job. So I think that there's a misconception about the workload. Actually, of all of the orphans courts in Maryland, if we were to move to this system in any of the 19 lay jurisdictions, it would have the smallest impact on the circuit court in Howard County. As Senator Hester said, it's only about 2%. And I want to add on that as well, that the caseload in the circuit courts has been steadily declining. So between fiscal 2020 and fiscal 2021, just as an example, if the circuit court for Howard County took over these duties, its caseload would still decrease. So the idea that they can't handle it is simply incorrect.
And the last question, I know a good senator is saying that this is a local bill, but there's certainly been testimony from some of these other orphans court judges that in reality it isn't a local bill because anyone from anywhere in the state could be affected by, decisions that are made by this orphans court. Would you mind rebutting that in defense of this being a local bill?
Yeah. If you agree with that argument, then no changes should ever be made to any local system. You shouldn't have passed the changes in Baltimore City, Baltimore County, or Prince George's, and you shouldn't, the legislature back in the 60s and 70s shouldn't have made the changes in Montgomery and Hartford. You know, are you going to allow for local courtesy or, you know, yes, absolutely. I mean, we have, when someone dies in Howard County, they have family all over Howard County, all over the state, all over the country. We have people abroad that are affected. But obviously, you know, these changes were made not that long ago in your county and others. So this sort of, as a principle, I don't believe in slippery slope arguments having much merit. And I will, lastly, as I said earlier, despite the content of some of these letters you've received, in my experience, having been in a leadership role in the Registers Association, working closely with the leadership of the Estates and Trust Section Council of the Bar, I have heard no proposal anywhere else in the state to do what we're doing. So this idea that this is going to lead to, I've never heard of it. And since I've been involved in this, I would have heard about it. But in all these other jurisdictions, you know, we have a couple members of this committee who represent counties where they have lay courts. I don't hear complaints about them, you know, but the contrast is that we have, you know, I was just emailing a gentleman this morning who is going to appeal another order of our court. And that's what we're dealing with every day.
Gotcha. Mr. Chair, the gentleman and I used to serve on, we used to be in leadership Howard County together. So
5 years ago, actually.
Yeah.
Time flies.
But I do appreciate it. Thank you.
Thank you, Senator.
I don't know what they put in the water over there, but you both turned out all right, so there you go. All right. Senator Bailey.
Just briefly, where is the judiciary on this?
The judiciary doesn't take positions on bills like this. So they've taken no public position.
So, but the judiciary, it would fall into the realm of the judges of the circuit court,
Yes, yes, sir.
right? So it clearly is going to increase their workload for those judges.
Yeah, and just to give you an idea, I mean, the average number of cases are, the Orphans Court only has usually 1 or 2 hearings a week. Many of those hearings are held on the court's own initiative in cases where I think a circuit court judge would not hold a hearing. And so I think that the impact on them is actually going to be a lot less than people think. And again, as I said to Senator Sidnor, the drop in their caseload, they can more than accommodate for this. And as it was mentioned earlier, I think Senator West mentioned that an awful lot of this work is desk work. You know, we're not talking about criminal trials. I mean, frankly, if I were a circuit court judge, I would welcome, you know, a fee petition or a petition to probate a copy of a will over a divorce hearing or something like that. So I think that clarifying that is important.
Thank you.
All right. Further questions for the committee?
Thank you very
Seeing none, thank you both very much. Thank you.
Thank you, Senator.
Thanks. So next we'll hear from, I think that concludes the testimony for the proponents of the bill. We'll switch to the opposition panel, and we'll hear from Nicole Miller, Jacob Deven, Ann Dodd, Paul Carroll, Melissa Bright.
Good afternoon. My name is Nicole Miller, and I served as an Orphans Court judge in Howard County 2014 to 2018. I submitted a brief written testimony for you stating the benefits of having an Orphans Court. I hope you'll read. Today I come before you, though, in person to speak about the more real and human aspects of why you shouldn't abolish this special court. After graduating from the University of Maryland, I came to work as a courtroom clerk in the Circuit Court for Howard County. Upon learning about how the Orphans Court operates and how it differs from the criminal and even the civil cases I was sitting in, I decided as a proud lifelong citizen, being compassionate and service-minded, I should one day serve in this position. And so I did. These are exactly the kinds of traits Orphans Court judges possess, and that the grieving people coming before the court need and appreciate. Once during a hearing of a mother and a wife, co-personal representatives of their loved one's estate, where they had such animosity towards each other, but both grieving the loss of the young man, I asked them, Why did he pick for the two of you to work together in this capacity if you despise each other? They both testified that they used to be so close, the best of friends. In a more relaxed and approachable atmosphere, they were able to talk it out, and later they thanked us for leading their hearing in a way that was professional but not scary, allowing them to air their grievances and let us guide them to what was equitable. This is what the Orphans Court is to the people of Howard County and all over Maryland. Orphans Court judges are elected by the people and are accountable to the people. Please vote against taking this resource away from the people of Howard County. Thank you.
May I remove my mask, or would you prefer I take? Thank you. Mr. Chairman, members, I'm Ann Dodd. I'm the Chief Judge of the Howard County Orphans Court. I'm speaking on my own behalf, and I'm here today because I believe it's important to preserve the Orphans Court in Howard County. Not because it'll benefit me politically, because it will not. I could throw up my hands and say, oh well, and walk away because this will be my final term. But I don't think that's the right thing to do. And I'm not retiring because of this threat. Associate Judge Turner will also be retiring at the end of this term, but for the fact that there's a docket today, she would be here in person, and we have submitted written testimony. I've served on the court for 12 years. I'm a lay judge. I'm the only lay judge on this court. It takes 2 judges to sign any order. So an attorney judge signs every order that comes out of our court. I believe I've served honorably. I have diligently pursued judicial education. I spend endless hours researching the law and reviewing estate files. My work has never been confined to 1 day a week. I was elected to the chairmanship of the Conference of Orphans Court Judges twice by both attorney and lay judges, and was elected president of the Maryland Association of Judges of the Orphans Court. So I've been privileged to see all angles of the court from various vantage points. In spite of what they may have heard or what they may have been told, the Howard County Delegation is sponsoring this bill based on the persuasively misleading statements of the Register of Wills. The Register has a rocky relationship with the court. And while both the Register and I testified at the delegation's hearing, it was at the work session held immediately before the vote, to which both the Register and I were invited to attend, by the way, that I was not allowed to respond to the derogatory and misleading statements made about the court. And no member of the delegation except for except for Senator Lamb and Delegate Kittleman will return my calls. So I've not been able to speak to them. There hasn't been any sound reason to articulated why the citizens of Howard County should lose a court that serves them in the least restrictive environment. And you would have to believe that Howard County, one of the fastest growing counties in the state, won't continue to grow to accept that the abolishment of this court won't have a negative fiscal impact on the state, the county, and poorer residents over the coming years. Thank you for this opportunity. I hope you'll ask me some questions that you asked Mr. Mcfarland, because I would like to respond to some of those things about appeals and whatnot.
Excellent. We will ask questions, if there are questions from the panel, at the end of everyone's presentation.
Thank you.
Thank you very much.
Good afternoon, members of the committee. My name is Jacob Devin. I'm an attorney. I practice law specifically in the area of estates and trusts. I make regular appearances in front of the Orphans Court throughout the city. Not just Baltimore County, where I live, not just Montgomery County, where my office is. I'm everywhere. And I happen to think that the Orphans Court is a really good thing for the state of Maryland. It's a very great service for all of your constituents. These judges, be them attorney or lay people, I'm always blown away at how they're willing to take the time to hear people out, people with attorneys and without, people who just need to get some tears off their chest. I'm always blown away at not just the attention to detail of how they hear the law, but how they hear the people who are before them. There was a comment made by someone who was in favor of this bill stating that it was a slippery slope to say that, you know, this bill is not a local issue. It's not a local issue. I appear regularly. I'm not a citizen of Howard County, but I still appear there. The last 2 times I was before the Orphans Court in Howard County, the people sitting at the bench on the other side of me were not citizens of Howard County. It's just the way it is, you know. We all have an opinion about what happens. What happens in Howard County has an effect on people in any of your jurisdictions. I, you know, was previously opposed to the formation of a committee that was to analyze the Orphans Court because I thought it was an attempt to try to take away the Orphans Court. But I was very pleased when their final decision did not say that, you know, the Orphans Court should be replaced with the Circuit Court. That was not one of their recommendations, and I think we should listen to what that court decided based on what the information they looked at. Anyway, thank you for your time.
Thank you for letting me speak. Thank you for letting me be here today. I'm Paul Carroll, the Chief Judge of the Orphans Court in Taubee County, and I am a layman, and I spent my entire 75 years in Taubee County, and as a layman, I feel like I do a good duty to our citizens who come to our court. I guess I should say, as I'm an Orphans Court judge in Taubee County, I come here today as an individual capacity and not on behalf of the Maryland Judiciary of any parts of that. So as we have talked about the Orphans Court, it's been a great experience for me. One of the first things, I had a chance to meet Judge Dodd as she was the chairman of the MAJOC, and I've been a member of that for the last 3 years. And she was excellent as a leader, and I've had a lot of respect for her. As far as for our court, there's 3 of us, and one is an attorney. He's retired. He spent his entire career dealing with estate planning, and the other judge and myself are laymen. And so the 3 of us work very well together with our register will. She's excellent, and if we disagree, we can talk. The 3 of us can decide what needs to be done, and it's just harmony. And I love my job. I've been here 8 years, and I'm hoping to get elected again. But I must say, to hear some of the comments that were made in a negative way, I haven't heard that from where I've come from. So as a layman, hearing people come before our court, we're more relaxed. We do wear a robe, so sometimes people might get intimidated with that. But overall, things were solved in a much better way, in my opinion, because they're dealing with less formality than the circuit court judge. Thank you.
Your permission to then ask? Is that okay? Okay, thank you. Thank you very much, Mr. Chair, Mr. Vice Chair, members of the committee. My name is Melissa Bright. I'm the Chief Judge of the Orphans Court for Wicomico County, Maryland. I'm a lay judge, but I've been there this is my 28th year behind the bench. I'm also the current president of the Maryland Association of Judges of the Orphans Court, and I'm here today for myself and for MAJOC, not for the judiciary or any of its parts. There is so much I want to say to you, and there isn't time in 2 minutes. So I'm going to be very blunt, because at my age, I understand that life is too short for BS and lies. So I'm going to tell you the truth, and I'm going to say it bluntly, and that's just the way it is. This bill is not a local bill. As you've heard, it has ramifications across the state, but it's not a local bill. It has been sold to the Howard County Delegation and then to the House Committee based on inaccuracies, incomplete so-called facts, and blatant untruths. And if we have had time, I would answer every one of the things that Mr. McFarland said. and either agree with it or show you why it's not true. And I hope that you will take the summer to find a lot of this out for yourself. But just as for instance, with all due respect to the senator who spoke first, she mentioned that only 19, I think she was the one who said only 19 counties in Maryland, they're the only ones in the country that have lay probate judges. That is untrue. There are multiple states in this country that have lay probate judges, and Georgia alone has lay judges in 67 of its 159 counties. 22 states in the United States of America have lay judges in criminal cases who are hearing the cases and sentencing. So lay judges are not necessarily the problem. Appeals, you need to know they go to the circuit court de novo, which means they are heard fresh. The circuit court's not necessarily hearing the same case the orphans court heard. And in the two cases that Mr. McFarland referenced, those were cases where fees were denied because they were being asked to take the entire fee at the beginning of the case. And I know I'm over my time, if I may say one more thing. I'm asking you not to put this bill through at this time. It's not a local bill because, and Mr. McFarland was right there and heard it. He says he hasn't, but he heard it. In her testimony to the House Committee, Delegate Atterbury, the sponsor, said, and if you look at the tape from the March 2nd hearing, 1 hour, 47 minutes, and 50 seconds into that tape, that's 1:47:50, Delegate Atterbury says clearly, this year Howard County, next year I believe we should take a look at the entire state. She may not have said the word entire, but she said look at all of the state. It is clearly the first gambit in a larger plan to abolish the orphans court, and there are lots of good reasons not to do that. Thank you for letting me go over. Thank you for hearing us today.
Thank you for your testimony. Senator Sidnor.
Thank you very much. I have a few questions. One,
Would you like up here, sir?
first I have Ms. Dodd. If you
Yes.
could address the question about the appeals, or
Sure.
the number of appeals that,
I'd be happy to. First of all, you understand whenever you have two parties who are on opposite sides, you're going to make somebody mad. I've been on the bench almost 12 years. I have dealt with approximately 10,500 rulings. We have been appealed 43 times. We have been overturned on appeal 2.5 times. 2.5 times. And one of those was from a de novo hearing in which the venue was found to be incorrect, which was never an issue raised before us. Does that answer your question, or could
Yes.
I give you more information, sir?
additionally, would you mind, because unlike my colleagues, I was not on that work
Task force.
or task force. What's the interaction between your court and the register? I mean, how do you all work together?
Frankly,
Or how should you be working together?
well, the statute describes the register as being clerk of the orphans court. He's to act under the direction of the orphans court. He, however, believes that we should be acting under his direction. If he does not like an order that we sign, he has sent back orders telling us to reconsider. He is an elected administrator. He is not a judge. The proper course for orders that are, in which there is disagreement, is to go through the appeal process. And it's not our fault that it takes 14 months, 12 to 14 months for an appeal to be heard. That's the proper route to take. The Maryland rules don't allow us to give up our responsibility to the register because he disagrees with us. And as I said, the court is made up of 2 attorney judges, and I'm the lay judge. So there isn't any order that goes out with just lay judges signing it. It doesn't happen.
Okay, thank you.
Thank you, and thank you, Senator Sidnor, for giving her an opportunity to speak to appeals. But it's very interesting. First, I want to thank all of you for your service, and I'm deeply appreciated that you all come from other parts of the state to speak on behalf of orphans court judges as well. The email that I was referencing came from another member of the Orphans Courts Task Force who was there asking the questions, right along with me over the summer. So we appreciate you. So when we were trying to figure out what makes a good orphans court good and a not so good, we really, really struggled. Me not being an attorney, of course I said, well, if something gets appealed or if it gets overturned, it obviously should point back to the unpreparedness of the judge. And I was flat out told, well, Ron, that's not the case. There are evidentiary things. There are lawyers who aren't up to snuff as they should be. And quite frankly, when you talk about attorneys versus laymen, there are some places in the state where the layman's orphan court judges outperform those with the Harvard law degrees, right? And so there was not a one-size-fits-all. We recognize that. But I just wanted to, make sure you had the time to articulate what you wanted us to hear. And I'm supposed to ask you a question, but they're not paying attention. Is there anything else that you wanted to get across to us, before we let you go?
I really appreciate that. I'm a little nonplussed at our clerk going on social media degrading us. It's very difficult to hear.
Yeah.
About 14 months ago, the Register sent me an email. And in that email, he told me how much that he held me in the greatest respect, that I did a wonderful job. But what's happened in the last year is this issue of fees, in which our court, the majority on the bench, believed that the consent form, which was the contract between the attorney and the clients about the amount of money they would spend, kept under the statutory maximum, that it was talking about the amount. Indeed, on appeal, it was determined that it isn't just the amount, that we are not to enter into it at all. Our concern was that this attorney, and he had 2 cases, was asking for all of his fees up front. And we did not believe that comported with what the legislature meant by its consent form, and it seemed to us it was a loophole. So it went to appeals, which is where it needed to go, even though we were found to be wrong. In the meantime, the estates and trust attorneys listened to us, and they agreed with us. And Mr. Lastly drafted the bill that Mr. McFarland just told you was great. He drafted it based on our concerns. So now that's not going to happen anymore. Attorneys are not going to be able to use that loophole to be paid up front. They're going to have to earn their money. But our position on that did raise the ire of the Register of Wills, and he's...
I appreciate you. Thank you very much.
Thank you very much.
Thank you. I appreciate the work that you all do, and I'm very familiar with several of the judges of the Orphans Court in the counties that I represent, and they are all lay people. And I was just curious. I know that the training that they went through when they were elected, and I'd like to know if it's different for you all. Do you not go through the same training that our judges of the Orphans Court go through?
Oh, absolutely. We have mandatory training, annual training. As a matter of fact, in the last 3 months, or the last 9 months, every 3 months we have to take something, we've had to take something online. There's quite a bit of training that we take. The Register is not privy to that. He does not know what classes I take. But yes, I have met all the mandatory requirements and then some.
So thank you all for your service.
Thank you.
Seeing none, thank you all very much.
Thank you.
Thanks. And with that, that'll conclude
I
the.
appreciate your listening to us.
Of course, yes, thank you for coming down. All right, with that, that'll conclude the hearing for House Bill 868. We'll now go on to Mr. Jackson with House Bill 1021.
Afternoon, everybody. Chair Smith, Vice Chair Waldstreicher, members of the Senate Judicial Proceedings Committee. My name is Matt Jackson. I'm staff in the Speaker's office to present House Bill 1021. Speaker apologizes she couldn't be here today. She was over in Finance on a previously scheduled hearing. House Bill 1021 requires firearms dealers to install certain security features such as burglary and video recording systems and other exterior physical barriers on their premises. If the dealer is a small dealer, such as one that works from home, the bill only requires that outside of business hours, that dealer would then lock away firearms in a vault safe or another secure room on the premises. Dealers found guilty or found to be in violation of any requirement are subject to a fine of $1,000 for subsequent violations that are knowing and willful. Second violation would result in license suspension, third in revocation. And with that, that is the sum and substance of the bill. And on behalf of the Speaker, thanks for hearing this bill today, and I urge a favorable report.
First, before we begin questions, I want to say thank you for, I know this is a quick turn, so I really do appreciate it. I know that.
Yeah, no, thank you. Thanks for
All right,
accommodating me.
Senator Huff.
I'm just curious, part of the bill where it says that they have to, you have a store. I'm thinking of some of the gun stores. I'm not sure, in different parts of the state, maybe they're larger, but some of the ones in Frederick County up by me are kind of small. So it says that you can't, even if you have bars or whatever in the window at night and all that, you can't have the guns in the store. They got to be taken all to what, a vault or explain to me that part of the bill.
Yeah, so on page 3 of the bill, yeah, we actually worked with the Maryland Licensed Firearms Dealers Association with regard to some of these concerns. So beginning on page 3 of the bill, A1, it sets forth what a kind of secure premises or a secure building is. We heard this from the larger entities that had too many firearms to lock up, like long guns and whatnot, and also heard from smaller entities where they're doing a few things working out of their house. So in line 28 on page 3, we put the or in there. So if you're a large dealer, you have like a burglary system, video recording, and one of the following features, such as bars or security screens on exterior features. You can keep your firearms in the shop as long as those factors are met. But if you're a smaller dealer, beginning on line 29 at the bottom of page 3, if you're outside of business hours, you then just have to take your firearms and lock them up in a vault, safe, or some other secure room inside of your premises. So, and that was put in there directly to address some concerns raised by the licensed firearms dealers.
So at least one of the following features designed to prevent the unauthorized. So you have to have at least one. So you have to have bars, security screens. What is a security screen?
This was actually something that was specifically requested by the licensed firearms dealers. I view them as, I had to look them up myself. They're just kind of like something that you would see where you kind of pull it down, kind of like a door, like a garage door almost feature. It's like a metal grating.
Commercial grade metal doors, grates, or other physical barriers approved by the Secretary. So that's saying if they've got the glass windows, basically you're pulling something down over that at night.
Correct.
So they have to have that and a burglary alarm system that is continually monitored. So they have to have 1, 2, 3, 4, 5. They have to have one of those 5, and then a burglary alarm system. They have to have that as well.
Correct.
Okay. And if practical, physical barriers designed to prevent the use of motor vehicles to breach all buildings where firearms are stored. What does that mean?
So this was done, Baltimore County, I think it was in 2017, 2018, 2019. They had some of the things smash and grab, similar to something you would do at an ATM at large storefronts. And so the idea was to stop that from happening, but as we heard from the various dealers, some, you'll have them on a second floor, you'll have just a house and everything. And some said it just wasn't practicable for them to have, some sort of barriers, although some already actually do. But that's just meant to stop someone from doing like a smash and grab.
Okay, so they have to do one of those, or outside business hours, the licensed dealer shall, I see what you're saying. So you're saying the larger ones will do these bars, security screens, or something like that, or outside business hours, the dealer shall lock all firearms stored in the premise in a vault, safe, or room or building that meets the requirements.
Right. And that cuts both ways. We were trying to accommodate larger dealers and then smaller ones that, work out of a smaller private facility where they can just lock them away inside of a secure room, inside of a home, or some sort of vault or safe.
Okay, thank you.
Welcome, thank you.
So if I was just a FFL, if I had an FFL dealer's license at my home, how does this bill affect me in that regard?
At your home, this would fall under on page 3, bottom lines 29 through 30, that outside of your business hours, I assume like when you're not working on a firearm, there would be certain things that would have to be locked away in a vault safe or a secure room. And the secure room would be something that would be similar to what is under paragraph 1 back on page 3.
So if I'm a FFL dealer dealing 1 or 2 guns a year, right? So I don't have any issue like that. I might buy a gun for myself. Or I might buy one that I sell because I have the license. Whether I sell one or not, I'm required to now have this just because of the fact I have a dealer's license?
No, I believe that this would touch on retail operations, so I think that I believe that you would only have to do it if you're working on firearms meant to be sold as part of your business, not that firearms that you're keeping and maintaining as part of your collection or as part of for sport.
So is what you're saying that the dealer's license is a different license than the FFL?
So the way that Maryland is one of the states that requires if you have an FFL and you're going to be dealing in the state, you pay a nominal fee. I think I'm not sure exactly how much it is, but you pay a fee within the state on top of the FFL to then become a Maryland firearm dealer. So this is just that.
So the dealer's license that I would have would allow me to purchase firearms.
The dealer's license that you would have, would be for you to purchase and sell firearms, right?
Right.
As an FFL dealer, just like anything, it doesn't expand the scope of the license. It sticks to.
Right, that's what I was getting to. So if I have the license, whether I'm going to sell the firearm or not, for purchasing the firearm, then I would be required to have this security system?
If you were under your prior scenario, if you were a smaller entity, then you were purchasing these firearms for sale as an FFL dealer, then yes, you would, under the legislation, you would be required to lock them away in a safer vault or a secure room.
I guess my question is, and maybe the license has changed a little, but when you would purchase an FFL, you would have an FFL dealer's license. Some of the large collectors actually have that. They have no intention of selling a firearm, but they have the FFL dealer's license to be able to possess and buy those licenses for themselves.
Right. And the intent of the bill with the lead-in on page 3, lines 8 and 9, is the licensed dealer may not conduct business. So if under your scenario, if someone has an FFL so that they can acquire firearms that are, someone who doesn't hold an FFL would be required to hire, you're not doing it as a business, you're saying you're doing it as more of a collection or whatnot, correct?
Right.
I don't think that would fall under this legislation.
So if they were just buying and not selling, that would not be covered under this legislation?
Yes, Senator.
Okay. All right, thank you.
Thank you.
All right, I know you've got to get going, so I appreciate you presenting the bill, and we'll get to work on it.
Oh, thank you all so much. Thanks for having me today.
All right,
First time
thanks.
in here.
There.
It's wonderful. Thank
There
you.
you go. Thanks,
Thank
good to have
you.
you. Good to see you. Said no one ever, yeah, right. All right. All right, with that, that'll end the hearing for House Bill 1021. We have one bill left, but the sponsor is tied up in a hearing, so we're just going to take a 5-minute break, recess, and we'll come back to hear the bill. All right, Senator Lee, whenever you're ready to go, we will start your hearing.
Mr. Chair, this is SB 977, which codifies the best practices for preparing a returning citizen for reentry into the community. This is, of course, a public safety legislation, not a human rights bill. Studies have found that restrictive housing is linked to a lot of negative psychological and physical problems, including depression, paranoia, anger, cognitive impairment, cardiovascular disease, and self-harm and suicide, but just a few, to name a few. While the Division of Corrections states that it has a commitment to returning offenders to society with tools necessary to keep them from their former life of crime, there's a lack of preparation for the daring event of reentry into the community. In Colorado, no one is released directly from solitary into the community. Rather, they implemented a graduated step-down program to prepare people for return. In comparison, from 2016 to 2018, Maryland released 834 people directly from isolation into correctional facilities after having spent an average of 60 days in restrictive housing. Of course, this practice endangers community members who could be the victims of these individuals who have not had the chance to step down. This puts our constituents at unnecessary risk. The bill simply allows for returning citizens who have 180 days left until the release, the opportunity to work with a reentry specialist or case manager. These specialized individuals assist in the transition from restrictive housing to living amongst the community. In 2019, if you recall, this committee passed a bill similar to the currently amended version of this bill, but the bill died during the last days of session. And I think some of the senators who are here today that were delegates voted for the bill on the House side, like Senator Watson, Senator Signor. This is common sense bill. Returning citizens face a significant event when they reside in restrictive housing one day, and then they reenter their community the next day. Their neighbors, our constituents, may suffer such a drastic event. For these reasons, I ask a favorable on SB 977. Any questions? Casserly?
Yes, on page 3, it says, generally the bill, yes, the only question I have is the grave risk. It said you can't not do this unless they prevent a grave risk of harm. Is that defined anywhere? Do we know what, is that a legal term, the grave risk of harm?
I think that's the terminology we used when we passed a bill. Senator Signor, do you have a copy of the bill? I'm sorry, I neglected to bring it. It was on my desk because I've been running from committee hearing to committee hearing. Okay, thank you, Senator Signor.
I don't mean, I'm sorry, I may be flippant, but I don't know what you mean by it's the it's the
Okay,
terminology
page
we
3,
use.
where now?
Page 3, line 16. It says a grave risk of harm. I mean, I've heard of imminent risk, serious risk.
I believe this, I'm not sure. Counsel, can you help me on this? Wasn't this the language that we used when we passed this bill? Okay.
Right.
We can find out, okay?
That's my only question.
We'll find out.
All right, thank you.
Okay, no problem. Any other questions? Thank you.
All right, thank you, Senator Lee. With that, that'll conclude the hearing for Senate Bill 977 and the hearings for the day. We're going to take how much time do we need?
Well, I don't see more members are presenting other committees, so.
All right, we have a voting session coming up, but we have to wait for members to.
Why don't members have their staff fill in for their hearings so they can come to the
Yeah, we should do that. We'll call them back. All right.
That's an easy one.
So give us 10 minutes. 10 minutes. We'll come back for voting.
Unless they're supposed to